Good afternoon, everyone, and welcome back to this week's episode of the Digital Law Podcast, brought to you by Digital Law and produced by Anson Evaluates. As a bit of background, we at Digital Law are a niche law firm specialising and working solely in the technology and cybersecurity law sector. In each episode, we look at recent stories in the news related to digital technology around the world, with a specific emphasis on data protection and cybersecurity. For more information on the stories that we're covering this week, please check the links in our show notes. By way of an introduction, I'm Amelia Davies, an apprentice solicitor at Digital Law UK, and I'm joined by Peter Wright. Peter, do you want to introduce yourself?
Hi, my name's Peter. I'm a solicitor and a managing director at Digital Law, and we've got a surprising number of news stories this week. We thought, it's going to be fairly light, and then sure enough, you start looking in a few of the sources, and there's always plenty out there, including some juicy bits of enforcement. So I'll pass back to Amelia to kick us off.
Thanks, Peter. So I will just cover the story titles to introduce what we're going to cover today, and then we will jump in. So our first story will be the guilty car salesman fined for retaining and selling data to competitors. Then we've got action against Sky Betting in gaming for using cookies without consent. Then we've got 1.4 million lost from email and social media accounts being hacked over the last year. We've then got Uber's terms and conditions, meaning that the couple can't sue after a life-changing crash. We've then got the Meta fine, and a thief blocking Wi-Fi to steal car keys. So a lot of interesting stories to cover. But before we dive into these stories, here's some background information on our podcast producer, Anson Evaluates. Anson Evaluates are a consultancy company offering a variety of services, including data protection training, outsourced data protection officer services, and specialising in advising clients over multiple jurisdictions. So, our first story. Guilty car salesman fined for retaining and selling data to competitors. So a man has pled guilty and been fined for unlawfully retaining and selling thousands of pieces of customer records from car leasing company he worked for in Hertfordshire. Shortly before he resigned from his role as a sales consultant and LeaseLine Vehicle Manager Ltd, Alexander Dorr sold over 3,600 pieces of personal information that he'd taken from the company's internal customer database. He then approached multiple competitor companies with this information, whilst claiming that the data belonged to him. Consequently, the breach was discovered in November 2022 and investigated by the ICO. So Dorr then pled guilty to unlawfully obtaining and selling data, a breach of Section 170 of the Data Protection Act 2018. He appeared at St Albans Crown Court on Tuesday, the 17th of September, and was ordered to pay a fine of £1,200 and £300 in costs. So this is one of the more interesting stories, where it's the fact that you've actually got someone getting a criminal record for a data breach, which is not something we often talk about on this podcast.
It isn't, but I was going to say this is sort of the latest episode in our recurring feature of those who end up being clobbered with personal fines and convictions in relation to
car sales people as well. This
data
is
breaches.
maybe the third or fourth in terms of car sales. So is that maybe a red flag in terms of specifically the car industry needs to tighten their braces in terms of these?
Yes, and it's interesting in that the ICO in this instance is only going to be able to work on things where the issue is actually reported to them. I say that because in some instances you might find that organisations find that employees do this and they might investigate and fire the employee, but do they necessarily report the offence? Because then, of course, you get a press release like this saying, this individual has committed the offence, and of course it's naming the employer. And some employers don't really want the publicity. So I know this happens both with personal data and even sometimes where fraud is carried out. So without naming names and individuals, a contestant on the Bake Off this year, Paul Hollywood, Prue Leith, not them personally, no. But so one of the individuals on there, and the new season started this week. So the reason why I'm talking about this for those overseas wondering what on earth am I talking about. So I think this is called the Great British Baking Show in the States or something. But anyway, that's a new competitor on that. Apparently, loads of people were shocked that he turned up, and this is being reported in the press today. that this guy was on the Bake Off when years ago he was fired by his previous employer, not just for the sale of personal data, but actually having his fingers in the till.
Oh, interesting.
To the tune of thousands of pounds. But the said employer obviously investigated and fired him, but didn't report it to the police. So, of course, Bake Off then come along. They will carry out standard criminal records checks, but they wouldn't actually turn around and indeed. So Amelia has just searched and found the name of this guy. But I'm not going to go into it for reasons of, this is on the news. If you want to do a Google search, you'll find it yourself. I won't actually talk about and name the individual. But yeah, so as a program, Bake Off does its criminal records check, which is searching those public available bits of information. But of course, Bake Off and Channel 4, it's not as though they can ask all of the financial institutions in the UK, have you fired anyone for dishonesty? No.
Nor is it reasonable to ask them to do so,
No, exactly. So what can you reasonably do? So that means that therefore apparently a load of people that worked at this fairly major national institution, financial institution, were like sort of, spurting their tea out when they saw their former colleague walking around the Bake Off tent, worried about whether his cake's going to rise or not. And so the point here is, taking it back to what happened here, is that in this instance, the ICO had the report and did something about it.
Yeah.
How often do employers not actually report it? I think if all of the instances that this happened led to those employers actually then dobbing in their employees, you and I will be talking about more instances like this during our podcast. But it just highlights the fact that this is in the law, and this allows for these fines to be applied to individuals. So the point that should always be made in any data protection training in any company, it isn't just, this is the standard data protection training that you've been beaten over the head with every employee you've had. The reason that they're actually telling you this is because it isn't on the employer's head, it's on you if you get it wrong.
Yeah.
And you've then got a criminal offence against your name, a conviction, which, guess what? You have to disclose as every subsequent employer that you go and speak to, because guess what? If you nick personal data, it's a crime of dishonesty.
There we go. And I think, like Peter said, we don't very often see that these are being reported, but certainly interesting when it is.
It is.
Moving on to our next story, we are looking at action against Sky Betting and Gaming for using cookies without consent. So the ICO have issued a reprimand to Bonterre Limited, trading as Sky Betting and Gaming, for unlawfully processing people's data through advertising cookies without their consent. So from the 10th of January to the 3rd of March 2023, Sky Betting and Gaming was processing people's personal information and sharing it with advertising technology companies as soon as they accessed the Sky Bet website, so before they had the option to accept or reject the advertising cookies. This meant that their personal information could be used to target them with personalized adverts without their prior consent or knowledge. So following the ICO investigation, whether Sky Betting Game was deliberately misusing people's information to target vulnerable gamblers, there was no evidence of the deliberate misuse found, but the regulator concluded that Sky Betting and Gaming was processing this data in a way that was not lawful, transparent, or fair. It doesn't seem to be a lot of wiggle room in getting out of this one.
There isn't, and it highlights, and funny enough then, the following press release from the ICO goes into detail around, well, what's the problem here? I think, first of all, a bit of context is that if you happen to turn on and watch any of I think it's called the EFL overseas, the English Football League, we call it Premier League, you'll notice that all of the clubs now, a lot of the clubs are sponsored by betting and gaming firms. And Sky Bet, not surprisingly,
popular ones,
because it's the channel that a majority of people end up subscribing to if you want to watch the football.
Indeed.
And therefore you're sort of being bombarded with the, come on, have a bet in play. They used to have the great big disembodied head of the actor who's bet in play, come on and tell you it's a bet in play. And you're like, okay, you almost feel you're being railroaded into it. I must admit, it's I've been in the room when, people with loads of bets on, and it's actually quite exciting. It makes the rather tedious exercise of playing football, which I've worked out, suddenly quite exciting and engaging, and I can see why people do it. However, the point here is that the Sky Bet website was clearly having fairly aggressive cookies, collecting lots of information about people going onto the site, and then not being properly transparent in terms of not just the cookie banner, but the information in what should be a clear schedule of cookies that tells you what cookies are on there, what personal data is being collected, how long it's stored for, all that.
And who it's transferred to, because it's not
Indeed.
just Sky that collects this information. This was then being shared with advertising
Yes.
companies to then target ads. So, you
Yes.
know, if you happen to mention just in passing that in your web browser cache history is, you know, jeans or something ridiculous like that, you might find a jean retailer popping up in your advertisements because, lo and behold,
Yes.
that data has been collected without your consent or knowledge, and now you're thinking, oh, crikey, you know.
Yeah, this is always the way these things will then follow you around the internet, wherever you may go. But the point here is that, I mean, we end up doing lots of advice for companies around, you know, they're setting up a portal or website or whatever, and we help them to make sure they have the correct transparency on their sites. So they don't get investigated and fined in this instance where cookies are being used without the correct sort of consent being in place or the right levels of transparency. What's interesting is usually we're the ones to flag up to a lot of our clients, have you done this? And they go, oh, no, we haven't. How do we do it? And we then help them to do it.
Yeah.
But usually they don't come to us saying, how do we make sure that we're being full, open and transparent with regards to the use of cookies? And I think that illustrates the problem. People still don't necessarily know.
If it's a proactive approach, then I think that's probably one of the main issues. You know, we've had quite a few clients through the door. They've been like, we've received this complaint, or we've received, you know, someone saying, well, you've collected my data, you know, pay me X amount to go away. That has been over, you know, a period of a couple of years. It's been quite a common occurrence. And then our clients turn around and saying, well, what do we do? Well, in many instances, it's like, well, you didn't really have the right stuff there in the first instance. We can help you put it together, but it's fighting fires rather than being proactive, which I think is one of the ICO's main push as well, because the ICO has been actually naming and shaming companies and individuals that have not been up to scratch in terms of the cookie.
Well, that's the second part of this story, because then they say they've gone through the list of the top 100 websites in terms of user traffic in the UK, and they found that, let's get the stat, they found that of the top 100, discovered issues with more than half of how these were using advertising cookies, and they therefore wrote to 53 of those top 100 sites to warn that they faced enforcement action if they didn't make changes to advertising cookies to comply with data protection law. There's been a positive response to this call for action, with 52 of the websites making changes to how advertising cookies are used. So there was one holdout. But the point there is that you therefore end up with investigation. And sure enough, the one that didn't, the one holdout, has then been named and shamed, and they're saying, we're now going to go after you. So this isn't something you can ignore.
No.
You can find yourself named and shamed. You can find yourself on the end of enforcement action. This isn't just, we have to comply with having this tick box on our website. There are very real consequences if you don't jump through this hoop.
Yeah, and I think it goes back to what we recently discussed in our previous article about, you know, you've got that bad person that's going to follow you around like a bad smell, because you don't really want that on your record. And as we all know, the internet is a great place to find absolutely anything and everything on someone, regardless of how long has passed.
Yeah. Easier just to have a cookie page on your website, isn't it?
Yeah, or even come to us if you can't work out how to do it yourself.
Indeed.
There we go.
Clang.
Moving on to our next story there, we've got £1.4 million lost from email and social media account hacking in the last year. So Action Fraud is warning people to provide an extra layer of protection and enable two-step verification, as more than 33,600 people had their social media or email accounts hacked in the last year. In the reports made to Action Fraud, there are various different methods of hacking reported, including on-platform chain hacking and leaked passwords and phishing. And so, you know, it's quite interesting to think that actually people can get quite cavalier in terms of their passwords for something like social media, but actually it can have a real lasting consequence. And while you see you've got 33,600 people here, is this a full picture? Because potentially these could just be the 33,600 people that reported this as an occurrence, but how many people kept it hidden because they were embarrassed to say that they had been hacked? That's anyone's guess. But certainly an interesting thought. Peter, I'll pass to you.
Yeah, I mean, indeed, the problem here is that we know that action fraud has its problems. It has its problems even actually keeping track of all the things that are reported to it, let alone trying to work out, well, what stuff doesn't get reported to action fraud. I mean, they're making the point here that this is all clearly very widespread, trying to say, look, try and make sure that you are keeping your accounts secure. Again, they're banging the drum for two-step verification. But I think it's it's difficult to sort of encourage many people to do. I mean, it's one thing to say, oh, this is easy if you have, say, biometrics, on your phone, whereby it will take a scan of your face or a fingerprint so that you can get into your app, rather than having to go and jump through the hoop of entering that second piece of identification every time you use the app. But not all phones do that.
No.
Not all people are accessing their information through the phone. What if you are one of the many people who are online trying to use stuff who don't do it through their phone, but instead of doing it through a desktop?
And then I think the other thing is as well, where some instances you can have a verification app. It's like, well, then you've got an extra app on your phone and all of this, and you've got to jump through even more hoops for the two-step process. And that's not to say that we don't agree. I mean, a two-step or multi-factor verification is the best way to keep your passwords secure, because at the end of the day, the hacker or anyone else has then got various hoops to jump through in order to access your data, whether that be personal data or just stuff you don't want anyone else to see.
Exactly, and it's just a matter of, it's all well and good saying two-step, but all that means to a lot of people is, great, you're now making it even more difficult for me to get online to do the thing that I wanted to do. But as you're quite right, it does remain the best advice to stop this happening.
And when we say the best advice as well, we're not just talking about social media and email. We're talking about, for anything from, for example, we are a law firm, we use cloud services, therefore, having multi-factor authentication is vital for us. And that applies to many other industries as well.
And indeed, many apps will demand two-step verification anyway. So anything from, for example, the NHS app through to your mobile banking apps and things.
I know my uni requires two-factor authentication to log in now.
Yeah.
So certainly something that is becoming more widespread in usage, and for good reason.
Absolutely.
So moving on to our next story. This is looking at Uber terms, meaning that couple can't sue after life-changing crash. So a couple who are left with life-changing injuries after their Uber crash have been told they cannot sue the company because of the terms that they accepted when using the app. So Georgia and John McKinney from New Jersey in the US are bound by a clause saying they could not take the case to a jury in a court of law. The state judges ruled that they clicked a confirm button on the app on more than one occasion when asked if they agreed to Uber's terms of use. But the McGinty's argued that they had not understood that they were forfeiting their right to sue the company. They told the BBC that the most recent time that the terms were agreed to was when their daughter, which was around 12 at the time, had accepted the terms prior to ordering a pizza on Uber Eats. Arbitration means that the disputes are settled through a third party rather than in court, and in this case is a lawyer appointed by Uber. So this is quite an interesting case, and potentially not strictly in the kind of legal tech field that we'd normally discuss.
Yeah.
But nonetheless, it seems to be a bit of a trend, because this case has parallels with Disney's attempt to avoid being sued after a death at Disney World. And in this case, the terms covered a Disney Plus membership before the company then changed its mind.
Yeah, so what's interesting on both of these is, of course, they've got US corporations applying these fairly draconian measures to their customers in the US. So we're talking here about Uber's US terms of service, which says, by the way, by ordering your cab, you can't sue us for anything that happens. So in this instance, a quite horrific road accident and life-changing injuries, yet you can't actually sue Uber for that, which of course is a bigger issue in the States where you're going to have these sort of medical expenses anyway. We were talking in this instance, what if this happened in the UK? Well, in the UK, you've got, in theory, consumer protection measures. So you've got the Consumer Rights Act.
Yeah, Contracts Act.
An updated version of the consumer rights legislation was passed for online things within the last 10 years. So you've got a fairly up-to-date piece of legislation there. You've got the Unfair Contract Terms Act, You've got the sale and supply of goods and services. So there's lots of things governing in effect and stopping, in theory, this sort of sharp practice. Furthermore, you wouldn't be pursuing big medical bills in the UK. It'd be more a personal injury claim for sort of paying suffering, loss of amenity, etc. Though, of course, depending on where this happens, as we were talking about earlier on, in different parts of Europe and the world, you could end up with significant medical expenses. In some instances, that would be pursued via an insurer, potentially, rather than a private individual seeking to do it. But in this instance, you've got private individuals who did not know that by clicking accept on those terms of use that they were therefore basically giving away their right to a jury trial, which you still have in the US. It's a constitutional right. But in this instance, you were actually saying, I give up my constitutional right to this.
It's very interesting that this appears to be a trend, because we're specifically talking about Uber here, but a similar thing was happening with Disney, and the fact that essentially this couple had gone to Disneyland, I believe it was Florida, with their family, and unfortunately one of the people involved suffered a major allergic reaction and died after being assured that whatever was in the food that she couldn't have was not in there, not present, etc. And then, lo and behold, unfortunately, she then died. However, they were told that they could not sue because they had agreed to Disney Plus membership in a similar way to the Uber terms. And it was interesting because Peter, you were saying, well, this is actually somewhat common practice in the US.
Yeah.
And that was not something that I kind of heard of before, because you do get, when you are signing up to these things, you do tend to get a plethora of information that 9 out of 10 people probably do not read. You probably, like me, scroll to the bottom and think, great, thank you very much, didn't read that. Agree.
Click, accept, move on, and you don't necessarily realise what's buried in there. So the salutary lesson is always the Human Centipede episode of South Park, where one of the boys doesn't realise that they have, by clicking consent to the Apple user license, I think it's the Apple user license, then suddenly you realise that you're going to be in the middle of the Human Centipede.
Delightful.
It's a really stark example of you click accept on these things and you don't know what's in there. Now, there have been examples in the UK of companies trying to say, well, they accepted it at the terms of service, and the court's gone, no.
Yeah.
It is not reasonable to construe that the user understood what they were accepting when they clicked accept on your terms of service. So therefore, the use of the sort of 45-page opaque terms of service is increasingly restricted, I'd say, in many jurisdictions. But certainly in the US, it continues to thrive, and examples like this will continue to proliferate. We'll not go down the rabbit hole of arbitration and why it's more popular in the States. Suffice to say, it's a symptom of the fact that to go to a jury trial is not just expensive, it can take years. And then even if you get to a decision from that jury, then it might be the case that it can be appealed. So then you end up with these things sort of rolling on for years and years and years, huge amounts of costs that probably end up dwarfing the actual sum at issue, and no one really getting any effective resolution. So in many instances, actually agreeing to binding arbitration can be a good thing. But it then depends on how independent is the arbitration. The point here is it's not an independent third-party arbitrator, it's a lawyer appointed by Uber, who you'd hope would think about the ethical implications as a lawyer, and therefore usually, for example, I, for example, am a solicitor of the Supreme Court in England and Wales. I'm an officer of the court. Therefore, I'm under an obligation to think quite carefully from an ethical perspective when making certain decisions. You would hope that those similar ethical considerations will be thought of in whichever state the US lawyer where that Uber have appointed is practicing. But that still means that sometimes people very often are left feeling that they aren't actually receiving justice in having agreed to the arbitrator. But the point is that at least you can get a resolution by going through the binding arbitration, often years, if not decades ahead of where you would otherwise have got in a jury trial. But that is part of a much broader discussion around access to justice in the US. And we don't have time for that. We don't have another year on this podcast to discuss the internet for that.
Thanks, Peter. Okay, moving on to our next story. We are looking at Meta. I mean, would it be a podcast, a digital podcast, without talking about Meta or X? I don't think it would be, to be honest. But nonetheless.
This week's Tech Corporation Enforcement of the Week.
Indeed, yeah. Is that a new logo we're gonna have to start?
The jingle and everything, yeah.
So Meta have been fined 91 million euros, which is roughly 75 million pounds, over password storage. So the Facebook parent company Meta has been fined 75 million pounds by the Irish Data Protection Commissioner, the DPC, following an investigation into the storage of passwords. An inquiry was launched in April 2019 after Meta notified the DPC that it inadvertently stored certain passwords of social media users on its internal systems without encryption. So the DPC submitted a draft decision to other European data watchdogs in June 2024, and no objections were raised by other authorities. So Meta has essentially been found to have breached 4 of the general data protection regulation principles in doing so. So there is a lot of red flags, even in the very short piece of information that we've been given on this. Peter, I'll pass over to you.
Yeah, so in this instance, 91 million, a comparatively large sum to most of us, a fairly small drop in the ocean sum to Meta, one of the world's most valuable corporations. In this instance, has been fined by the Irish Data Protection Commissioner. Not to sort of repeat what we've talked about ad infinitum ad nauseum in the past, but Ireland is the regulator of choice for Facebook in Meta in Europe, because they are the regulator in the state where decision making takes place. So basically, Ireland has Meta's European HQ and all of its servers there, so therefore it is the regulator, and it has handed down this fine. They are being fined because they were storing passwords in plain text, which is a fairly basic breach of the European General Data Protection Regulation, GDPR. Obviously, if you've got the passwords to people's social media accounts being stored in plain text, totally unencrypted, unprotected, then that's going to be a risk. Look back to our previous story in this episode.
I was about to say, and now we go in this episode.
Where we talked about social media accounts being hacked. So yeah, it kind of says this is a risk. So yeah, they've been reprimanded and had a fine. And let's just put this in context. So in May of 2023, Meta was fined 1.2 billion for mishandling data when it was transferring it between Europe and the United States. That was also from the Irish Data Protection Commissioner. That was the largest fine imposed under GDPR to date. And then in 2022, Meta was also fined 265 million euro after data from half a billion people in 106 countries was published on a hacking forum, having been scraped from Facebook years earlier. So there's a steady stream of enforcement against Meta. This is merely the latest example of it. I'd say what's the big takeaway from this? It's the fact that it's the use of the word inadvertent. Yeah. Meta says it was inadvertently storing these passwords on a server in plain text without the security measures such as encryption in place. The fact that such a large corporation with almost unlimited resources to throw at its tech stack would find that there was that sort of error.
It's not fairly with a great deal of confidence, does it?
It doesn't. I mean, let's not speculate on what that revealed, but I think it does say a lot about the fact that, you know, Facebook's now been going for the best part of 20 years. It will have legacy systems like everyone else. There will be older and newer bits of tech being used. And in this instance, there was obviously something on one server somewhere that was not reflecting current acceptable standards. So in that regard, Meta's just like everyone else.
Thanks, Peter. Moving on to our final story of the episode. So a thief blocked Wi-Fi to steal car keys. So a car thief who blocked people's Wi-Fi to disable doorbell cameras so he could break into their homes and steal luxury cars has been jailed. So over a period of 12 months, Damon Keegan took almost £350,000 worth of high-value vehicles, the Greater Manchester Police has said. When he was arrested in November 2023, he was found with a radio frequency jamming device used by criminals to block mobile telephone and Wi-Fi signals. The 31-year-old was jailed for 6 years and 11 months at Manchester's Minshull Street Crown Court. This is quite interesting because, like we said at the top of this episode, it's not very often we cover jail time, really, in our podcast. We're very much looking at fines or where the ICO reprimanded someone. But again, we're looking at quite hefty jail sentence here. But it's very interesting in the use of tech. And this really goes into the nitty-gritty of how tech can be used for good, but also bad.
Yes, and this actually ties in. We were talking, I think, in a previous episode not long ago. We were talking about, I think, how very often in criminal proceedings now there is a reliance on video evidence, CCTV, by law enforcement when it comes to securing convictions. It's a lot more reliable than the old way of, did someone actually see you and doing an ID parade? If you've got the video that shows the individual and they can be identified either from what they're wearing, if you don't get their face, are there other things that they're wearing or that they're doing that clearly identify and place them at the scene of the crime? It means that you're very easily able to then reach that beyond reasonable doubt conviction.
Yeah.
In this instance, this individual has worked out that the proliferation of Ring doorbells around the country means that if you are on someone's driveway taking their car, more than likely the fairly large, and you'll know from when you're walking up to a house with a Ring doorbell that really loud
ding, ding, ding.
chime goes off when you're actually a good few feet away. So that's going to pick up, if that doorbell is angled on the driveway and that's where he is with his trying to jimmy open a door, then it's going to pick you up, and then there's the evidence. And even if you pick up 4 or 5 cars during the course of an evening, then you're going to end up on the CCTV. So if you can stop that from happening, that's going to give you a significant advantage. Not to mention the fact then that if you've got the ability to jam those signals, it may then mean that you can open the car without the use of the classic crowbar. I mean, in this instance, there's a picture on the BBC news article that reports this. There is a picture of the guy's backpack, the burglary kit, containing all of the items that he had. So he had everything from your classic wrench and a screwdriver and various things to try and jimmy things open, but it looks like he was also using tech where possible to then be able to cut off Wi-Fi networks and potentially probably use different signals to try and unlock a vehicle without having to resort to some of the tools that he had. Point was that, of course, when they did pick him up and all this stuff was in the backpack, it's fairly clear what it was he was looking to do. So again, we're getting to that beyond reasonable doubt on the criminal conviction. But this is basically illustrating the fact that you do have the career criminals who are increasingly wising up to the risks in their profession and doing something about it. And obviously, as well, it's going to be somewhat, it's not great for the individual. Not only is your car nicked, but then, of course, you will feel that your home has been violated and that your Wi-Fi network may have been disabled or certainly blocked, and the kit that you brought to try and keep your possessions safe has been subverted, which obviously isn't great either.
Well, on that cheery note, that's the last story of the episode. So that was our last discussion, and if you do have any questions about what we have discussed today, then please feel free to email us at admin@digitallawuk.com. A summary of today's stories are available on our website, as well as the links to the original stories containing more information. And if you'd like to hear more from us, including information about subscriber-only podcasts, webinars, and events, then please subscribe to Premium via our Patreon channel using the link in the show notes. A big thank you to Anson Evaluate for helping us to produce this podcast. And if you'd be interested to hear more about Anson Evaluate services, please take a look at their website that you can find at www.ansonevaluate.com. And just a reminder, these episodes are available on our website, YouTube channel, and podcast channels as well, such as Spotify, Apple Music, Amazon. So please feel free to leave us a review. Thank you for listening, and we hope to see you again next week.